The camera's turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky. We're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com. You know where to go. Call or text that number. Let the power flow. 702-381-4295. Nevada for Nevadans. We're still alive. Power back to the people. Power back to the people.
Oh, that's right. Get those roller skates ready. Good morning, Nevada. When the ooh comes in and the ah comes in. How are you guys doing today? It's Tuesday. Ready? I'm on my roller skates today. Good morning. How are we doing, Nevada? Welcome back to W4Nevada Live. My name is Matthew Winterhawk, and we are just minutes away from the start of Day 8 in Coyote Springs Investment LLC versus the state of Nevada, live from Department 13 before Judge Mark Denton. Amelia Cargill remained on the stand, and Nevada is expected to continue cross-examination today. When court adjourned on Day 7, the state had spent hours building the argument that this was still an unfurnished administrative process. Workshops, technical reports, interim order 1303, stakeholder meetings, and repeated agreements to wait for further state engineer action. Coyote Springs continued to stay. The practical result was already clear. The permits remained alive, but the development could not get the approvals needed to build homes. So that is where we pick up this morning. Did Nevada leave Coyote Springs with a real path forward, or did the process continue while the project itself remained frozen? We'll be following the testimony closely, separating attorney questions from evidence, and bringing you a full breakdown at every recess. Court is scheduled to begin at 9 a.m. This is W4Nevada Live. 17 counties, 1 Nevada, we the people, we the press. So good morning, Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Douglas. We're going to say you again because I'm thinking about this data center thing that you're supposed to be having going on pretty soon here. We're going to look it up. Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine. All 17. Story, Washoe, White Pine. We got all these counties, right? Not just 2 in a sports book, right, Clark and Washoe? We love you. We do. Just not as much as you love yourself. So we're going to get into that today. We've got it up and ready. The court, we're waiting for that. Currently, I'm in the background, and I am looking into an issue with effluent water in Elko. There is a meeting going on, Elko City Council, and it's dealing with permitting and priority usage of, during this drought season, of the effluent water rights. So I'm in the middle of digging into that. I'm also in the middle of unveiling and working on a project. I've been given a lead into, let's take a look while we're waiting. I have been giving a lead into a possible, I don't know, what would you call it? I can't really say fraud yet. I can't say these things yet, but what I can tell you is that I have witnesses firsthand that state that Ritter Enterprises and or Ritter Ranch's JD Ritter, Ritter Enterprises, which was Ritter Ranch, was somehow bought out through subsidiary and third party agreements through an LLC that was created called JD Rye Ranch. We'll get into that. Tied into the Walker Basin Conservancy Group that was supposedly directed, federally supported, and had National Fish and Wildlife Foundation ties. And now we're finding out that Walker Basin Conservancy has been taken over and bought out the water rights from Walker Basin, who originally received these from Ritter Enterprises or Ritter Ranch, was expressly told never to sell the water rights to Dave Perry or Perry and Sons Farms in Urington and Lyon County. So they formed this LLC, this Jagtar Singh, Stephanie Johnston, and Brad Johnston, who were all associated and tied into Perry and Sons Ranch. They formed this LLC to buy the water rights from Walker Basin Conservancy that apparently that they were never supposed to have. But initially, when Ritter Ranches sold the water rights, what is that weird noise? That was like a doorbell. I guess the court's starting to move around. So the water rights are moving from one to another LLC, but this LLC is connected to that who had the original land. They were able to buy the land. They sold Perry the land. They said, you'll never have the water rights. But then the water rights were circumvented utilizing this third-party LLC from employees and management from Perry, all to the same address where all the Perry's and Sons Farms addresses go, now having 574.55. It's astonishing to me the amount of moves people will go to obfuscate from the public. So I don't know what we want to call it yet, but if what has been said by many people is true, that Ritter never wanted Perry to have water rights, sold water rights to keep the Walker Basin and or Walker Lake restoration project. There's a couple federal projects. Like, this needs to be looked at. So we're working on that. Anyways, let's get into this court case. We're back here today. It is Tuesday. I'm excited. Let's get it going. We got less than a minute. You know, Theron, while we're waiting here, let me pause this diction that I have on the side. I saw your comment. Yeah, the issues with water rights, it the amount of decreed rights versus statutory rights versus priority date, the connection is insanity to me. Uh, these companies, like what we're dealing right here, this case that we're covering today, is all about how they've basically commoditized the public's water. He or she who develops this water and is granted the permit eventually will give a certificate, permit, deed. It will be based on priority as to how their allotment or duty is serviced to them. So, like, say if we're in a drought, everybody else is going to have priority before that person, the last person in line. If I bought mine today and I get mine and it's, today's date, everybody prior or before me has priority before me. So what these companies did was run around and establish priority dates for their commercial developments and or commercial operations, which it existed at one point for farmlands and ranchers and even mining. But what happens is that residentials, Nevadans, they end up suffering in the long run. And one of the major components is that it has to be beneficial use. So they have a form, and I'm starting to educate water right holders to be able to protest anything that could be affecting them if they're in a down gradient basin. I'm starting to understand law to the levels at which I need to be start like assisting and applying this in the counties at which people are affected who contain and or retain water rights to fight and protest against other people who are utilizing their water rights during these drought situations and pumping and selling for commoditized profitability for private enterprise and or personal enterprise to protect the rights of Nevadans water. It's it's really a hot topic and a subject that is it takes a lot of pieces, a lot of facet, a lot of law. Even understanding here, which someone informed me that we had new rulings that judges and or magistrates that oversee water precedents and cases need to be SCR 18 certified. Judge Denton isn't, but Judge Denton also was involved in this case many years, so I think that's why it's kind of like a grandfather prior to this certification of SCR 18 processing of cases. There's water's fun. I really enjoy water, and it gives me a reason to get up every day to fight to make sure that it's being taken care of in the right way. And we're good stewards of these natural resources, not as if the count like I'll tell you what, Nevada's Office of Conservancy, our water engineers, we're compromised at all levels that are supposed to be protecting water inside this state. I want you to understand that right now. Which this case is, that's why it's so critical to me that this case is covered. And everybody today will probably be watching Tupac Shakur or looking for the Tupac Shakur case. That's not what you need to be watching. I promise you that. We need to be watching this. This affects your life. Tupac Shakur is pop culture.
So I feel a little bit perplexed. We're not what I'm gonna do. It's nothing dramatic, but. That's a problem. That night. Yeah, it's a little part. That's another thing. That's what I'm fighting with. With Uber. Gonna be probably above 50 with my Uber. Because it's an event. next outside.
I'd ask Judge Hardy to put him on a special setting. So you know, on Monday, you know.
I was even thinking about calling.
We should practice Monday, we put it on special setting.
Offers if they would draw me up. That was.
Yeah.
No,
No, it's an especially.
we'll see guns and roses.
It's not hard to convince him if you have another trial going on.
Be my fourth time.
All rise. Order 13 is on session. Honorable Margaret N.
Good morning, please be seated.
Morning, Your Honor.
Reconvening for non-jury trial in Coyote Springs Investment LLC versus State of Nevada. Please state appearances of counsel. Identify parties and party representatives who are present today.
Good morning, Your Honor. Mark Hutchison and Todd Kennedy on behalf of the Coyote Spring Investment LLC plaintiff and related entities. And with us is the general counsel of Coyote Springs and related entities, Ms. Amelia Cargill, and she is on the witness stand this morning. Thank
Good
you.
morning.
Good morning, Your Honor. Jeffrey Sylvester and Matthew Nealand at Sylvester and Plinick on behalf of the state of Nevada.
Good morning. All right, witness is taking the stand. You realize that you're still under oath.
Yes.
All right, you may resume.
Before I resume the examination, Your Honor, just a housekeeping matter I'd like to put on the record. Last session with Ms. Cargill, we had admitted a number of different documents that were conditionally approved. And the condition was based upon whether or not those documents were in fact posted on the public website. Over the break, I provided information to counsel to allow him to verify that those documents were in fact that were conditionally approved were in fact posted on the website. What I'd like to do is go through those exhibits that were conditionally approved and have those conditions removed, if you will, from the admitted document.
All right.
I would start with exhibit 3639, 3637, 3630, 3633, 3641, 3642, 3632, 3644, 3650, 3648, 3649, 3670, 3669, 3678, and 3677, and finally 3704.
Your Honor, with the representations of counsel that those were the exhibits that were subject to that conditional admission, and those were the ones that we discussed over the weekend, of which I have no doubt. We have no objection to removing that conditional
All right, so ordered.
admission.
Understand.
Thank you.
Just let the record reflect I'm handing Mr. Hutchison a summary of the documents I just placed on the record, so he can verify it if necessary.
Yeah, I'm accepting counsel's representation.
That's fair. Just want you to have it.
Appreciate it very much.
Okay.
So ordered.
Okay, Ms. Cargill, I want to circle back momentarily on the discussion we were having, not before the break, but sometime last week, with respect to how much money Part E paid to CSI in connection with the purchase and sale agreement and the various amendments thereto. So, Brendan, if I could have CSI's proposed exhibit 529, please. And tell Ms. Cargill if you can identify that document.
Yes, that is a document that came out of our files at Coyote Springs.
On the, you can see in the footer, it's as accounting, Coyote Springs investment, and then you can see printed at 9/10/2013. Is that how you read it?
Yes, it is.
Okay. And can you describe for the court what this document purports to reflect, please?
This is a document that our accounting department would have kept, and it shows all of the payments by category that Pardee Homes of Nevada made to Coyote Springs. The first column are the payments made toward the single family what I call the single family residential agreement.
If I can just interrupt you for a moment, Your Honor, I'd offer CSI's proposed exhibit 529, please.
Can I just, counsel, just see that? No objection, Your Honor.
Submitted.
It's already interrupted, Ms. Cargill. Talked about the first column, the single family payments.
Yes, that represents the payments that Pardee made to Coyote Springs arising out of the single-family residential agreement. The next column, multifamily payments, those payments arose from parties' payments under the multifamily purchase agreement. The next column, custom lots, those payments arose from parties' payments related to the purchase and the agreement for the custom lot agreement. The next column, golf course, town square. May I see the total at the bottom of that column, please?
Second page, please, Brendan.
That relates to, I believe, only the Eighth Amendment to the single family agreement. I would need to look at the Eighth Amendment, but my recollection is that relates to the purchase under the Eighth Amendment to the single family agreement. The next column is the water commodity charge. That was a calculation that Mr. Whittemore came up with Mr. Lash and Mr. Andrews related to a payment for Coyote Springs to hold and develop the water rights, meaning drill the wells and all of that. It was Pardee's share of their 87.5% of the single family residential units. The next column is water purchases, and that relates solely to the purchase of the water, the payment for water related to the Moapa Dace. Pardee paid for reimbursed CSI for 50% of that 460 acre feet of water based on a purchase price of $6,050 an acre foot. And the next column, the BLM easement, I believe there's only one payment in that column as well. Can we see the bottom of that column, please? Yes, that represents Pardee's, I believe, 50% share. I would need to go back and look at the jointly financed improvements chart, but I believe that was 50% of the payment when the easement in favor of the Bureau of Land Management for the power line was moved from the east side of US 93 to the west side of US 93.
All right, Brendan, if you could focus on 002 and just highlight the bottom calculations, please. So just for the clarity of the record, Pardee pays to CSI $84 million as in for what's referred to as single family payments. Is that accurate?
Yes,
And then the multifamily payments total 42,305,000?
$42,305,700.
And when it says multifamily payments, that's actually acquiring multifamily properties to be upon which multifamily units are to be built.
That is correct.
Okay.
By Pardee,
By-
yes.
And then the custom lots, that's the 2,995,000. And the golf course town square, that's the Eighth Amendment you to the best of your recollection?
Yes, Mr. Sylvester, we just have to pull the Eighth Amendment up to make sure those numbers tie out, but I believe that's accurate.
And does that include the repurchase of the golf course to your recollection?
What do you mean the repurchase?
They paid $1.8 million for that portion of the golf course. Is that, we went over that testimony before. We showed you a copy of the transfer deed of the golf course and related property.
That's why I'm saying we need to look at the Eighth Amendment to make sure that the number ties out and what it was comprised of. I don't remember the various components of it.
Okay. The water commodity charge, as you described, is $12,900,000. The water purchases, and I think I missed your testimony. I apologize for that. What were the water purchases again?
If that is the column that is for water purchases, the 1,391,500, that was Pardee's 50% share of the Moapa Dace water, the 460 acre feet of water. If it was calculated at 6,050 an acre foot. And so if you multiply 6,050 times 460, you get a number and you divide that number in two, and you should come up with 1,391,500.
Okay. So the total amount of payments made by Pardee over the span of time, I would assume from the initial purchase and sale agreement through all of the amendments is the 151,092,200.
That is what this worksheet reflects, yes.
Brendan, would you please bring up the state's proposed exhibit 3367. I'm certain it's been admitted under another number. But this is amendment 1 to amended and restated option agreement for the purchase of real property and joint escrow instructions. Do you recognize that document, Ms. Cargill? You want to see the signature page?
No, I don't. I'm just making sure that I know which agreement it is. So I'm just tying it out to the different dates. Yes, I recognize this agreement.
If it hasn't already been offered, our state would offer proposed exhibit 3367.
No objection.
Submitted.
Brendan, please go to 0004, please. And highlight paragraph 12. Is this the water commodity charge you were referencing?
Yes, it is.
And you indicated that it is in connection with their proportional share of improvements. Did I get that right?
No, it is exactly what it says that it is here. It is a water commodity charge, and it is related to buyers' use of the water at Coyote Springs for buyers, 87.5% of the single family residential units. And there was a formula that Mr. Whittemore and Mr. Lash and Mr. Andrews agreed upon to reach that $150,000 a month.
So it wasn't tied to actual use of the water? Is it just an estimate that the parties agreed to?
No, it was tied to a purchase price.
Okay, did party use that water during the time period that it owned and controlled the 2,600 acres, to your knowledge?
They would have used some of that water for dust control purposes, and perhaps I don't know if they used it in their construction trailers or not, but they definitely used it for dust control purposes.
Okay, Brendan, please turn to, I believe it starts at 0014. And this is what we've referred to before as the agreement with respect to jointly financed improvements. Does that comport with your recollection of the document?
Yes, it does.
And that's the document you referenced just a few moments ago in response to one of my questions, the JFI.
Yes, it is.
Just so we can, if you would, please read in the first paragraph, if you will, with respect to the division and the proportionate share of improvements.
CSI and Pardee proportionate share of improvements, 12.5% CSI, 87.5% Pardee, parenthetical. Assume CSI share of 2,000 equivalent dwelling units in Clark County on all listed infrastructure during the life of the existing option agreement, and parenthetical.
So the 87.5 is the proportionate share of improvement costs that parties required to pay, and we see the bullet points below with respect to what those items are. Is that accurate?
Yes.
Okay. And can you describe what the water treatment plant was?
The water treatment plant is the ground water treatment plant that where raw water comes in from the wells that Coyote Springs develops, and then it gets treated, and then it gets stored and sent out into the community for homes and businesses and the like.
And then as it relates to power substation, is that related at all to the Orr substation, to your knowledge?
That is
Bill Orr, I'm sorry.
That is the first power substation that was built at Coyote Springs, the 3 megawatt Bill Orr substation.
And they were to pay the 87.5% of that cost. Is that accurate?
The way that it worked, yes, that's accurate, but the way that it worked is Pardee actually paid for all of the costs, and Coyote Springs would then reimburse Pardee through a true up at the end of it after everything was complete, and CSI had the option to pay for its 12.5% with land at the then purchase price of the land based on the escalation schedule.
Was that true up ever finished?
No, it was not.
So in other words, if I understand your testimony, CSI didn't transfer property for their proportional share of that Bill Orr substation?
You know, Mr. Sylvester, I can't recall. What I meant was it was never finished. It were what they would call reconciliation meetings, where I did not attend those. It was amongst primarily the contract folks and the accounting folks, and they would go through the contracts and what had been paid for and what had been finished and agreed upon. And with all the party transfers that took place across the years, we would need to go through and really look at things to determine if any of the land that was transferred was ever transferred in satisfaction of some of the reconciliations. I don't remember sitting right here today.
Okay. If we can just turn to 0015, please, Brendan. And I just want you to look at the second full paragraph and just read that paragraph into the record, and then I'll ask you a couple of questions when you're finished.
CSI and Par D proportionate share of improvements, 50% CSI, 50% Par D, parenthetical, relates to sharing of the wastewater effluent system constructed for all of Coyote Springs during the life of the existing option agreement, end parenthetical.
When it says wastewater treatment plant, what is that improvement? Can you just describe what that improvement is or intended to be?
It started off to be the full 3.1 million gallon per day full wastewater treatment plant that is in the far southeast corner of the Coyote Springs community, which we've seen video footage of, and I believe we saw a video of Mr. Russell down inside of that. And then when Party realized that that was going to be just too big and too much for day one, then they started the package treatment plant. And they didn't finish either the 3.1 MGD or the package plant. All they did with the package plant was they delivered a portion of the equipment to the site.
Okay. What was do you recall, at least at the time the agreement was entered into, what the projected cost of that wastewater treatment plant was going to be?
I do not remember, Mr. Sylvester.
And that's, I think you indicated in your direct examination, that was a cost incurred by CSI to complete that wastewater treatment plant.
CSI completed the package treatment plant, not the 3.1 MGD. The 3.1 million gallon per day plant is for the full build out of the community. Coyote Springs finished the package treatment plant.
And what was the cost and expense associated with the package treatment plant that you testified to on direct? You recall?
I don't recall. We'd need to pull up the contract for that to look at it.
And which entity did that work? Was that Meadow Valley?
It was in part Meadow Valley and in part HDR contractors or constructors, contractors, HDR.
Thank you. I want to return to where we left off last week, and we were talking about, Brendan, if you could bring up admitted exhibit 3715, please. And recall, this was the stipulation in order to stay the 1303 pending administrative process. Do you recall that? Generally, take your time if you want to walk through the document a little bit.
May I see the next page, the page 3? Can I go back to page 2, please? Thank you. Thank you.
Does that comport with your recollection? It was a stay to, it was a stipulation to stay that 1303, then pending petition for judicial review.
I would agree. I can't recall if this was the 1303, if this was our petition for judicial review against 1303 or not. If I could see the original complaint that,
I'm sorry to interrupt you. Let me just point you to the caption. That might make it easier. The top.
thank you. Yes,
I didn't see the mental.
thank you.
So. we can
Yes,
agree
I
this-
would agree. This is the petition for judicial review of 1303.
When we last left, we were talking about, we looked at the amended notice of hearing that Micheline had drafted, and it talked about the time parameters for the briefing and the hearing that was going to occur relative to the upcoming 1303 proceedings. Do you recall that generally?
No, I don't.
That's okay. Brendan, would you bring up admitted exhibit 3719? This is the administrative, I'm sorry, it was the stipulation in order to state, I'm sorry. It is the procedural background, and the title of it is amended notice of hearing, and it discusses the hearing that was going to be upcoming. We went through this in some detail before we broke. And just tell me if it refreshes your recollection as to what this was for.
May I see the following pages, please? Yes, thank you.
Okay, and we're looking specifically at 0002. And in the sort of the middle of 3/4 down of the second paragraph, where it begins the state engineer, it goes on to talk about the first step. And we had some discussion about what you understood that to mean. And essentially you said it means what it says, or words of like effect. I just want to ask you this. Did you understand, well, going back to this settlement agreement, you agreed to, that is CSI agreed to participate in the administrative process in good faith. Do you recall that language?
Yes, I recall that language.
And you agreed that 1303 was at least in part the ongoing administrative process?
I don't recall saying that, Mr. Sylvester. Is that a question? I'm
It
sorry.
is. Yes, it is.
Is the question, do I remember that? Or is the question, was it?
Either. I mean, do you know whether or not the public workshop process and then ultimately the 1303 adversarial proceedings were part of the administrative process that CSI agreed to participate in good faith?
CSI participated in all hearings in good faith. I am missing the call of your question.
That's right. You know, the agreement says participate in the administrative process. I'm just trying to define for you, if I can, or get your understanding as to what the contours of that administrative process were. My question to you is, did you understand that the public workshop process and the 1303 administrative hearing, the evidentiary hearing, were part of that administrative process?
The state engineer certainly said they were. Unfortunately, my thoughts at this point are clouded, and my thoughts are clouded because I now look at what the state engineer did, and it's hard for me to separate in my mind, knowing now that 19 or 20 days after we had a settlement meeting, which the state engineer had said, before the settlement meeting, I'm going to deny their maps. He had in his pocket something he'd been working on since June of that year that he called a curtailment order. And it's hard for me to think that what they did was in good faith. And so
I appreciate your response. It really isn't the field of my question. Just trying to understand if you knew and understood. Setting aside who participated in good faith or who did it. Just that was part of the administrative proceeding.
It was a part of what the state engineer identified as as an administrative proceeding.
And did you understand at the time that the settlement agreement was signed and the administrative process was defined by the state engineer, that that would be a two-phase process?
Objection ambiguous. Foundation.
All right, I'll do a better question. You're the COO, you were at the time of the settlement agreement, correct?
Yes,
You were general counsel at the time of the settlement agreement, correct?
yes,
While you didn't negotiate, you were certainly present for and approved the document to be executed by your clients, correct?
Objection misstated prior testimony.
I was present and I certainly couldn't have overruled Mr. Sino III or Mr. Sino Jr.'s desire to enter into any business transaction.
Just looking for your foundation to address the objection. I'm trying to understand, if you knew, and if you don't, that's the answer, that at the time the settlement agreement was executed, that there was going to be a two-phase administrative process.
Same objections. Overruled.
I don't remember sitting here right now at this moment, knowing that it was a two-phase process. I just don't remember.
After the execution of the settlement agreement, as you're going through the public workshop process, did you come to learn that the administrative process was going to occur in two phases?
Didn't I just answer that? I don't remember, Mr. Sylvester.
Even through today's date, do you have any understanding that the administrative process was going to occur in two phases?
At some point in the continuum, I became aware that the state engineer was bifurcating the process.
And fair to say you can't remember when on that continuum you first became aware of that? Is that accurate?
Sitting right here, right now, I cannot, if you show me a document that it makes it clearer to me, I just don't sitting right here, right now.
I'm just trying to prompt your recollection. And I'll show you a document that might help you in that regard. I'm just trying to look for your best recollection if you could get it. If I can go back, Brendan, briefly. To 3715. And if you go to 002 and to the footnote, if you could expand that, please, so Ms. Cargill can read it. And so I can read it.
It's rather blurry.
Can you make it a little bit bigger, Brendan? Or are we maxed? Do your level best, Ms. Cargill, to read into the record that footnote if you can.
Footnote 1, NRS 533-365 sub 6 governs the procedure concerning verified protests filed by interested persons against the granting of an application. The relevant administrative process concerning the Lower White River flow system and the state engineer's interim order 1303 does not seek to resolve verified protests against granting applications. However, by entering this stipulation, the state engineer agrees to be bound by NRS 533-365 sub 6 statutory timeframe for purposes of this proceeding.
Did you understand at that point that there would be a second phase that would attempt to resolve conflicts?
Objection ambiguous. Foundation. Overruled.
Mr. Sylvester, sitting right here, right now, I don't remember what I thought when I read that, and I don't remember what that particular NRS section means off the top of my head. What it says, rather.
Brenda, can I have volume 3 of Ms. Cargill's deposition, please? And start at page 162 through 25, and then 163, 1 through 19, please. Oh, My apologies. May I approach the witness, Your Honor?
Yes.
Thank you. What page?
Thank you. 162 and 163. You there, Mark?
I'll just have to watch the video for now.
Yes, please.
At page 12, the bottom right-hand corner, it says in the second, at line 6, and the purpose of the hearing is not to resolve or address allegations of conflict between groundwater pumping within the lower White River flow system and Muddy River Green Rights. That is not the purpose of this hearing, and that's not what we are going to be deciding at this point in time. Purpose of this hearing is to determine what the sustainability is, what the impact is on decreed rights, and then addressing and resolving allegations of conflict. Should that be a determination that will be addressed at a future point in time. And this was in advance of the upcoming 1303 evidentiary hearings. Do you remember that generally?
Yes, I remember
She's
this.
indicated that the issue of conflicts will be decided at a later date.
Yes, I read that in the transcript.
Does that refresh your recollection that there's going to be a second phase or a phase 2 in connection with resolving conflicts?
Yes.
Okay.
Is this the same as what we were just looking at? Is this referring to the exact same document?
No, ma'am.
Okay, thank you.
So when you testified that you were aware there's going to be a second phase resolving conflicts, did you have some understanding as to what that second phase resolving conflicts was intended to do? Only if you know.
I would rather read a document of the state engineer that specifically said what it was, so I'm not guessing as to what all it might have been.
No, I'm not asking you to guess at all. I'm just having reviewed that transcript and hopefully refresh your recollection. Did you form some understanding at that time with respect to what the second phase was intended to do? The answer is I can't recall. I accept the answer.
Objection, asked and answered, foundation. Overruled.
Mr. Sylvester, I feel like we've talked about this before, and I feel like in the whatever 28 or 30 hours I've been on cross, I feel like I've answered that question. And so if I can say anything I've answered on that topic previously, the conflicts to be resolved, to include everything I've said before, the conflicts would have been for the state engineer to, let's assume it's the 8,000 acre feet that is in 1309, then it would be how the state engineer is going to stop everyone below 8,000 acre feet to stop pumping.
Okay.
I mean, to me, that's a pretty simplistic view of resolving conflicts, unless there's some other view that the state engineer comes up with.
Okay, I'm just asking for your best recollection, and I think you've given it. Thank you. Recall that in advance of or prior to the scheduled 1303 hearings, CSI submitted a proposed map and report to the state engineer for its review and consideration in an attempt to satisfy the 1303 sort of carve out with regard to the moratorium on maps. Do you recall that generally, the time frame?
Objection, ambiguous foundation.
I'll leave the foundation. Do you recall submitting a map and a report to the state engineer in June of 2019, attempting to establish that there was water available to satisfy essentially the exception to the 1303 moratorium?
I'm not sure if it was in June of 2019. The years may be sliding together in my memory at the moment. I recall submitting a map with a report from Stetson Engineers designed to demonstrate that Coyote Springs could proceed.
And I don't want you to be disoriented in time, and I can happy to show you that email of June. It attached a report of May from Stetson, but let me ask you a broader question. Do you know whether that report was submitted in advance of the upcoming hearings or after?
Sitting here right now, I believe it was submitted in advance, but I would need to see it in order to say so definitively.
Brendan, may I have states admitted exhibit 3700, please? Just to refresh your recollection as to the date. Just take a moment to review that document and tell me if it refreshes your recollection as to when that was submitted.
Yes, it does. Thank you very much.
Okay, so we can agree it's in advance of, because recall back on the pre-hearing notice we looked at, it was going to be held in September of 2019.
Yes, the end of September 2019, and this letter stated June 13, 2019.
Okay.
This one wasn't in.
I know. Okay. To your knowledge, did the state engineer consider your correspondence and the Stetson report?
Section ambiguous foundation.
We just talked about the letter, right? The June 2019 letter.
Yes, we did.
It attached the Stetson report, right?
Yes, it attached the Stetson report and a Mylar map.
All right, I'm only asking, to your knowledge, did the state engineer consider your letter and the Stetson report?
I don't, not for some time, based on the emails from Doug Chen and from, I believe, Albert III. I know that Albert III and I met with Mr. Wilson on July 31st of 2019. And then I know that Mr. Chen sent any number of emails and the response was basically, we haven't done anything yet. So. And we didn't hear anything until 2 days after 1309, 2 days, 3 days after 1309 was issued.
Brendan, can I have state's proposed exhibit 3726? And I think this may be what you're referring to. There's a number, it's an email chain. I'm just going to ask you to page through it to orient you in time. So that I can ask you some questions about that. So just give it a review and let Brendan know when you'd like to go to the next page.
Next page, please. 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 Is this the last page?
Yes.
Okay. That is at least one of the email chains. I can't remember if there was more than just this email chain. I know I recognize this email chain. I don't recall if there was another email chain as well.
Okay. If it hasn't been admitted, state offers proposed exhibit 3726.
I believe it's in, but no objection, no.
Admitted.
So if we can go, Brendan, please, to that same exhibit at 0006. And by the way, typically, or not typically, from time to time during the administrative process, as we discussed, would you have direct communications with the state engineer? You personally, Ms. Craig?
A few times, perhaps to submit letters or responses. My recollection is the only time that I ever met with Mr. Wilson was when Albert III, Mr. Cena III, and I met with Mr. Wilson, Ms. Fairbank, and I believe Mr. Balatin was present. I know Mr. Balatin was present as well.
What were the circumstances of that meeting, if you recall?
Mr. Wilson had just been appointed either state engineer or acting state engineer. I can't remember if he had been appointed state engineer yet. And Mr. Sino III wanted to meet with him and just get to know him a little bit because he had had a few meetings with Mr. King. And it was what I would consider a formal meet and greet. It was a discussion about who we all were and where we came from and where we all grew up. And it was my recollection, a very formal, what I would call a formal meet and greet.
Okay, I'll represent to you that Jason King was the prior state engineer. Does that comport with the recollection?
Yes, it does.
I believe he retired the day he signed 1303 of January 2019, or the day after. Is that accurate from your understanding?
Yes, that's my understanding.
Did you understand that Mr. Wilson then became at first the acting state engineer and then appointed ultimately to the state engineer's position?
Oh, yes. I'm only saying I can't recall when that transition from acting to full state engineer occurred. And I don't remember if when we had that in-person meeting in July of 2019, if he had already become full state engineer or not.
Was that the only time you met with Tim Wilson, to your recollection, just that formal meet and greet?
That's my recollection sitting right here, right now. That date in particular sticks out to me, and I don't recall if there was another date.
Okay, so we were at 006, and it's the email from Doug Chen, and it's directed to Tim Wilson, copied Steve Shell. So I called Steve Shell this morning to check on the status of getting this map signed off. Steve said that you are personally reviewing this map, but that you are currently on vacation. And then the last paragraph indicates that the map was submitted with the report by Stetson, providing the verification of the quantity that's submitted on the June 13th date. Did you understand? I see that you're not copied on this. Did you understand from Mr. Chen that Mr. Wilson, as the state engineer, was reviewing that particular map and the Stetson report?
At this time, all I understood was as August 15th, when Doug Chen sent this email to Mr. Wilson. That's all that I knew, is that he had called Steve Shell, and Mr. Shell explained to Mr. Chen that Mr. Wilson was reviewing the map. And that was the first any of us had heard that.
So that's, I guess, what I'm trying to get to is, did you know at or about the time that Mr. Chen sent the email that, for instance, he reported back to you and said, state engineers reviewing the map and the report temporally?
Mr. Chen would have very likely forwarded this email to me and to Mr. Sino III.
And then you see on August 23rd, Mr. Tim Wilson, the state engineer, responds to Mr. Chen saying, "Thank you for your inquiry. The matter is still under review."
Yes, I see that.
Then on, so now this is August, I think, and the upcoming hearings are late December. They're going to October. So you're 60 days prior to that scheduled hearing, roughly.
Well, I think the hearing began before September 23rd, so we're roughly 30 days before.
By the way, I think you said you attended the 1303 hearings?
Yes, I did.
And CSI was afforded a full day to put on its evidence. Do you understand that generally?
I recall there was a schedule, and I don't recall how much time each of the parties had. I know that was in one of Ms. Fairbank's scheduling orders, that was all detailed out, who, what order, how much time you had to ask other people questions. Everybody went in a particular order. I don't remember how much time we had.
Brandon, go back to 3719, please, 0003. And you can see, I think this is in response to your recollection that they set forth the date and time and the amount of time each participant would receive to put on their evidence. And it looks like CSI is going to get September 23rd, the entire day. To your recollection, did CSI utilize that time to put on its evidence?
I would presume we had. I can't imagine we used less than a full day. But no, this is the schedule I was thinking of the parties that got, all day or more than a day. Yes.
And we can see the other participants, including U.S. Fish and Wildlife, National Park Services, Moapa Band of Paiutes, SNWA, Moapa Valley Water District, Lincoln County, Center for Biological Diversity, Dry Lake Water.
Oh, I don't see those others. My schedule stops
Sorry,
for
go to
Lincoln County.
Sorry, Ms. Cargill, next page. City of North Las Vegas, Center of Biological Diversity, Dry Lake Water, Georgia Pacific. And it goes on, Nevada Cogeneration, Money Valley Irrigation Company, Nevada Energy, and then public comment. And that took some time over the span of that hearing. Would you agree with that generally?
Yes, I mean, it went through as this schedule shows October 4th.
And was it fair to say that CSI was able to put on its experts and have them testify as to their opinions and findings?
I recall that we had experts there, and I would imagine that we had them. I don't remember how much time we used and who used what time.
And one of the experts you brought was Stephen Wright from Stetson. You recall that?
Yes, but there were others from Stetson also, one, possibly two others as well.
To get a full and fair opportunity, at least from your perspective, to put on your evidence to the state engineer in support of CSI's position.
Objection, cause for legal conclusion, foundation.
To consider understanding.
We were represented by counsel, I believe, Mr. Brad Harriman of Brownstein Hyatt handled that for us. And he did present all of the witnesses and do whatever he did, and we used our full day, I believe.
And then after that hearing, you recall the state engineer asking for closing statements from the various parties to set forth their position as it relates to what they believed should be the answers to the 5 questions that were the subject of the 1303 order itself.
I don't remember that, but I'm not surprised that you tell me that.
Brandon, if you go back now, please, to 3726. And at 0002, there's an email from Doug Chin to Tim Wilson of November 7th, 2019. And it's a lengthy email, and if you'd like to just peruse it, I'm not going to ask you too very many questions about it, but it goes all the way through, I believe, 0005, ending on 006. You can just let Brenda know if you'd like to go to the next page.
May I see the next page, please? Next page, please. Okay, it will depend on your question. I may need to refer back to the email.
It really is much more limited. Again, it is Doug Chin corresponding directly with the state engineer. You agree?
Yes, and he's copied Mr. Shell, Ms. Fairbank, and Mr. Sullivan, and himself.
And Ms. Fairbanks, if you recall, was then the deputy administrator. If you recall.
I think, I don't remember specifically when she took on that role, but I know at one point during her tenure with the state engineer, she was deputy administrator.
But it's from my reading of that, and tell me if you have the same understanding. Steve Shell is advising that the state engineer is reviewing the maps and the reports. Did you understand that? Generally, you reviewed the emails?
That is what Doug had conveyed, yes.
Remember, perhaps days ago, there was a colloquy between you and I about what maps were sitting in Mr. Shell's box in his office. And I think you derived that information from either participating in or reviewing this deposition. Do you recall at least generally that topic?
I recall the topic.
And I'd asked you then if you had some understanding as to what maps Mr. Shell was referring to that were sitting in his office for 2 years. And I think your response was you didn't necessarily know. Was that accurate? Is it
Objection.
an accurate recitation of your testimony? Sorry, counsel.
That's all right. Objection. Mischaracterizes a lot of prior testimony.
If so, she can so say.
I don't remember specifically what I said when we spoke about this a few days ago. Is that your question?
Well, I'm asking you now, having seen this, that there was a map submitted and then there were some responses. I'm just trying to prompt your recollection. If you have one, what Mr. Shell was referring to with regard to the box or the maps that were sitting in his office for 2 years.
Objection. Asked and answered.
Overruled.
I don't know which maps Mr. Shell was referring to. At this point, I do know there is a Mylar for the large lot map. At the time of this email exchange, the Mylar for the large lot map requiring 16 acre-feet of water is the map that Mr. Chen is following up on.
Right, that's the one that was submitted in June of 19 or a different one, if you know.
It had been submitted earlier. I remember you and I looked at an email and it was in a paragraph in an email and it described that the Mylar was submitted as well.
Okay.
That's my memory. Could be wrong. We just have to go back and look at that email again.
Mr. Wilson responds on December 2nd saying, thank you for your inquiry. I'm sorry, Brenda, do it again there, please. There we go. At 001, the subject map is currently under review.
Oh, I don't see that. Sorry.
There we go.
Okay.
I cannot provide any additional information at this time. Now, I think we can agree. Well, let me ask you a foundational question. Do you know when 1309 was published? Now, trick. I'll tell you what it is if I can find the date.
June of 2020, June 16, maybe. We need to look at it to confirm. I believe it was June 20 something. June 16, I mean 2020, but we would have to confirm that.
June 15th, 2020. I'll show you that document.
June 15?
Yes, ma'am.
Okay.
Okay. So at the time that Mr. Wilson is responding, the decision hadn't yet been made. It's receiving these closing statements and all of these things are going to be under his consideration for ultimately determination that leads to 1309. Do you agree with that generally?
Objection. Last foundation.
Sustained.
Do you know why it took from the conclusion of the evidentiary hearing until June of 2020 for the state engineer to issue 1309?
No, I don't know why it took that long.
Okay. And then on December 5th, 2019, Tim Wilson responds to Mr. Chen. And if you would, could you read that paragraph into the record?
Just the paragraph of the email or the header also?
Just the it's from Tim Wilson to Doug Chen, copied Steve Shell, Micheline Fairbanks, and Adam Sullivan.
On December 5th, 2019. Mr. Chen, thank you for your voice message of December 3rd. I, along with my staff, are engaged in a review of the totality of factors that relate to this office's responsibility in reviewing and deciding whether to approve subdivision maps. As you are aware, there are many factors relating to this project, and I am taking the time to thoroughly review the plans. I appreciate your ongoing patience as we continue to conduct our review.
I note that you're not copied on this document. Do you have a recollection of Mr. Chen having forwarded to you?
At some point, he would have, because I have seen it before,
Okay,
before today.
before discovery in this case? To your recollection?
To my recollection, yes.
Okay. Did you form some understanding as to what the state engineer meant when he referred to he was engaged in a review of the totality of factors that relate to his responsibility in reviewing and deciding whether to approve subdivision maps?
I'm not sure what Mr. Wilson is speaking about, seeing as how his prior order specifically said, if you provide this information, I have an exception that I can use. And he approved other water within the Lower White River flow system to be transferred or moved. I can't recall if it was a change in a place of use or a manner of use for technicrum that Mr. Chen referred to earlier.
So I think your answer was, and I'm not discounting the balance of what you said, you're not aware today, or at the time you reviewed this, what he was considering as to the totality of factors.
No, I'm not in Mr. Wilson's head.
Okay. To your knowledge, were there other pending subdivision maps before the state engineer in that same Lower White River flow system?
Objection asked and answered.
Overruled.
To my understanding, no, there were not.
Randy, may I have state's proposed exhibit 3737? And tell me, Ms. Cargill, if you can identify this document, and it goes all the way through 004. So if you'd like a moment to review it, and then we can have a couple of questions about it.
May I see the next page, please? May I see the next page, please? And the next page, please? Okay, thank you.
Recognize the document?
Yes, I do. Generally, I recognize the document, yes.
The first page of that document is the agenda and notice of publication. I'm sorry, public hearings. And as we go through to 003, tell me if you can identify that document as part of the collection of documents.
This is the general manager, Mr. Ensminger's information report that he was providing related to the proposed budget that they were submitting for the Coyote Springs Water Resources GID as the manager of that GID. I think this was a public workshop meeting, if I remember. I don't remember if this was the final meeting, but approving it, or if this was just the public workshop.
But you did attend that, as I think I heard you just, am I correct?
I'm not sure if I attended in person or not. I don't remember sitting right here. I could have listened to it. I don't recall if I attended in person or not.
If you would read into the record at 0003 under operating revenues, and that sentence that begins, however, please.
The developers' current plans are for the water treatment system and wastewater system to be operational before the end of fiscal year 2020-21. However, water sourced from outside of the Coyote Spring Valley will be necessary to support the contemplated development of Coyote Springs. This will impact the completion dates of the water treatment and wastewater systems. The budget is conservative and assuming no sales or water service connections. As a result, the fiscal year 2020-21 budget plan projects no operating revenues.
And this isn't the first time. I think we've already seen two of these operating budgets in your prior testimony, and you took issue with that language in those prior reports. Do you recall having that discussion with respect to prior general manager reports?
Objection, mischaracterized as prior testimony, foundation.
Sustained.
Do you recall seeing this in your prior testimony, cross-examination, a general manager report that had the same or similar information with respect to the need of CSI to obtain water from outside of that area?
I don't recall if it was this year 2020-21 or if it was a prior year that we had looked at. I just don't remember which other year we looked at. Or if it was this same year.
Okay. Fair to say, though, you took issue with this statement when either you were there or you heard it.
Yes,
And this was this position that the general manager of the GID had previously maintained from as early as March of 2017. That is, that CSI needed water from outside of the system.
Objection, asked and answered previously.
Overruled.
yes, that is why Coyote Springs objected to it, and the water district on behalf of the GID continued to tell us the same. This is, I believe, the year, maybe the next year. I don't remember what year, where Mr. Walsh and I appeared before the Board of County Commissioners, and Mr. Walsh told the Board of County Commissioners that until the state engineer resolved the issues, that the GID couldn't, the water district on behalf of the GID could not support the water resources.
I'd offer state to propose exhibit 3737.
No objection, Your Honor.
Admitted.
Thank you. I can have proposed exhibit 3735, please. Tell me if you can identify the document. And 3735.
Thank you. Yes, this is a letter from me to Mr. Walsh as general counsel of the Las Vegas Valley Water District, as manager of the Coyote Springs GID, relating to the agenda item 3 on the tentative budget for the Coyote Springs GID budget meeting held May 18, 2020.
Offer proposed exhibit 3735.
Is it just a single page?
Target.
Yes, no objection.
Hold on.
Admitted.
Now if we can turn to state proposed 3740. And this is order 1309, and just page through it to make sure that you understand to be this to be the final order, if you would.
Next page, please. Next page. You can, if you can just page through slowly one at a time, would be great. Thank you.
And you can see, Brittany, if you just turn to the 3740 of that document.
Which
then-
page?
I'm sorry, 0012. And just briefly, as we can thumb through some of these pages, it appears that the state engineer is outlining, if you will, in summary fashion, the various opinions by the participants, and we don't need to spend time going through them, but just scroll through those and recognize that there are a number of different parties or stakeholders that submitted opinions with regard to and following the 1303 evidentiary hearing. Just generally.
I'm sorry, what's your question?
I just wanted you to familiarize yourself that there were a number of different participants that their positions were summarized by the state engineer.
The state engineer summarized various parties' comments
And if we
in
were-
his own words, yes.
If we could turn to 0015, it has a reference to Coyote Springs investments. And it discusses essentially the opinions and conclusions of CSI. And we can see that falls into the next page. And then concludes at page 0018. So at least it appears that the engineer is considering CSI's position and conclusions that by virtue of the fact that it incorporated the same into the 1309 order. Would you agree with that?
Objection Foundation.
Sustained.
Do you have any reason why the state engineer would have included your opinions and conclusions if he didn't consider them?
The state engineer summarized what, in his own words. I don't know that they're word for word what Coyote Springs said.
Do you recall SNWA was one of the participants in the 1303 hearings?
SNWA and Las Vegas Valley Water District.
And do you recall that they took the position that some amount of water could be pumped from the carbonated aquifer without impairing decreed rights?
I don't recall that. I don't recall that they did or they didn't say that.
Brendan, can you turn to 0034? Let me just back up one so I can orient Ms. Cargill. At 0033, there is a summary begins with the Southern Nevada Water Authority and Las Vegas Valley Water District. And then if you could just turn to 0034. And Ms. Cargill, if you could read into the record the last paragraph on that page, please.
Based upon a review of the evidence, SNWA and Las Vegas Valley Water District concluded that current rate of groundwater withdrawals were not sustainable without adversely impacting senior Muddy River water rights and Moapa Dace habitat, footnote 193. Based upon the analysis performed by SNWA and LVVWD, examining the discharge from the Muddy River Springs area and groundwater production within the carbonate rock aquifer within the lower White River flow system, SNWA and LVVWD concluded that any groundwater development within the carbonate rock aquifer resulted in a 1-to-1 ratio capture of Muddy River flow, and that regardless of where that pumping occurred, it still resulted in a 1-to-1 ratio of capture, only that the period of time that the capture was realized was longer, footnote 194. Ultimately, SNWA and LVVWD concluded that while any amount of pumping results in a conflict with senior decreed Muddy River rights, approximately 4,000 to 6,000 AFA could be sustainably pumped from the aquifer, footnote 195. In conjunction with SNWA and LVVWD's evaluation of the quantity of water that may be sustainably developed within the Lower White River flow system, SNWA and LVVWD reviewed the interrelationship between discharge from the Carbonate Rock Aquifer underlying the LWRFS, groundwater pumping, and the impact on the habitat and recovery of the Moapa Dace, footnote 196. SNWA and LVVWD ultimately concluded that the flow required to sustain the Moapa Dace from adverse effects, including habitat loss and fish population declines, was a minimum 3.2 CFS at the Warm Springs West Gauge, footnote 197.
Ms. Cargill, did you read this when this order was published?
I read 1309 when it was published, yes.
Did you, when you read it, did you understand that SNWA left open the opportunity that some of the water in the carbonate aquifer could be appropriated without conflict? Just your understanding, do you have one?
It states that in that paragraph, assuming that this matches what SNWA had said at the hearing, and I don't remember that. However, even if 6,000 AFA could be pumped, then there's no pumping for Coyote Springs.
Unless some of those that fall within the 6,000 acre feet of water available can be canceled or forfeited. Do you agree with that?
Objection, foundation.
Sustained.
Recall, Ms. Cargill, last week, we talked about the fact that you could, that phase two, there could be an analysis of those water rights that existed senior to my words under that priority table could be canceled because they hadn't been used. Do you remember that conversation we had?
I know the table you're speaking of, yes.
I'm talking about the conversation you and I had with respect to the possibility on a go-forward basis that some of those senior rights could be canceled. You understand that just generally?
I understand that if the state engineer did the analysis, if there were any of those water rights that were not being used, they could be forfeited, abandoned, whatever the statutory process is that the state engineer can use.
And foundationally, do you have an understanding if some of those senior rights were canceled or forfeited or otherwise restricted, that might make more water available, at least within that 4,000 to 6,000 acre foot range for CSI's master plan community?
Theoretically, yes, I understand what you're saying, but that would have to be thousands of acre feet of water that was deemed to be unavailable at the senior level. Above CSI is what I meant on that chart.
And that's one of the proposals. Let me go back to time and Latham Foundation. You were talking on direct examination about the commencement of phase two. Remember that testimony on direct examination with Mr. Hutchison?
That feels like a lifetime ago, Mr. Sylvester.
You're not alone, Ms. Cargill.
Yes, I went to the 30-minute meeting in February of 2026.
And that was one of the criticisms that some had made, I think, including CSI, is that that process hadn't yet been done by the state engineer. Recall that, at least, Jim.
I don't remember if CSI made that comment at that hearing or not. I don't remember if Ms. Winston made that comment at that hearing or not, Mr. Sylvester. I'm sitting right here right now. I just can't remember.
So other than the fact that, I mean, I think you said, as I understand your testimony, yes, it's a possibility, but it would have to be I think you said several thousand acre feet to support the master plan community. That is several thousand acre feet of permanent rights that have been canceled or forfeited or otherwise restricted. Is that what your testimony was a moment ago?
It's simply math, right? If we take that chart and we look at that chart again, and it's just math. If the number is truly, as the state engineer says, 8,000 or less, then it's just math. How many acre feet have to be removed before Coyote Springs has its 4,000 acre feet available, 4,140 acre feet available for use.
One of the other things you said, as I recall your testimony, and correct me if I'm wrong always, is that it might well be that some of those senior permitted rights are not using as much water as they have been permitted. You recall telling me that last week or so?
I think if we look at that chart from 2017, yes, I believe that chart shows that there are folks over pumping, and it shows there are some folks that are either not pumping their full allocation or some fraction of their full allotted duty.
Just out of curiosity, have you ever attempted to do that math? In other words, look at the senior permitted terms and then compare those actual uses against the permitted rights?
I've looked at that chart and you can see it right on that chart. Are we talking about the same chart, the one that the state engineer published on the website? That's in Excel that has the highlighted portion. Is that the chart we're both talking about?
Let's use the term priority table. Use that before. Is that what you're talking about? I think we have the same understanding as to the chart.
That shows the 2017 pumping on the far right-hand side.
Correct. I mean, several columns, but I think we're talking about the same. I'm happy to show it to you, but I don't know if you know the chart. Maybe you do. Let's use that chart if you have it in mind. Have you ever attempted to, given the foundation you just laid with respect to, from review of that chart, some folks have not been using as much water as has been permitted, right? That's what you derive from your review of that chart. Fair?
Based on the 2017 pumping that's shown on the chart.
My first question was, I'll ask again with that foundation, is did you ever attempt to calculate the amount of water that would be available if, for instance, the state engineer limited the permitted rights, the senior permitted rights, to the amount that they are actually pumping?
No, I have not done that calculation you just described.
Did anybody do that on your behalf? CSI.
That calculation, no.
A similar calculation to the extent that, let me ask you more foundation. When you looked at that priority chart, did you look at those folks that had been permitted but hadn't yet established beneficial use? Again, the senior rights on that priority chart.
I have not.
Somebody on behalf of CSI undertake that analysis?
Yes, CSI retained a consultant under a privilege that did an analysis.
What privilege, do you know?
Consulting expert for litigation.
What litigation? This litigation?
One of the petitions for judicial review.
You say one of them, there was one in 1303, that was one of them, right?
There was the May 16th letter. There was 1303 and then 1309.
And then there was the PJR against Clark County Commission. Right?
Oh, I wasn't referring to that one.
Okay, but that's another PJR.
It is, but I wasn't referring to that
I'm
one.
trying to figure out of the 4 PJRs, if you have a recollection, when did CSI retain that consultant temporally?
I do not recall when that agreement was entered into for that project.
Did you receive a copy of the report?
I don't believe the report was ever finalized, Mr. Sylvester.
Again, I'm just trying to prompt your recollection. Do you know just in what calendar year you would have retained that consultant, and then when he would have or she would have discontinued that analysis?
Objection, question was asked and answered. Overruled.
I don't recall when I would have gotten that draft analysis. I just don't remember what year it was.
That's okay.
And I don't know that there's anything you can, and I'm not being critical. I just don't think there's anything you could do to prompt my memory on it because I really have no idea.
Do you know why it was not finalized?
Objection, that would call for work product doctrine or attorney-client communication potentially.
Sustained.
So other than that consultant that was tasked to do what you and I have just suggested, do that analysis to see how much water might be available. You don't know. Let me ask you, do you know what the results of that, at least preliminary analysis are? I'm not gonna ask you what they are, I'm just asking if you know what they are.
I have a vague memory, but I didn't retain the consultant, so
Who retained the consultant?
it was either Mr. Robison. I think it was Mr. Robison.
Well, that limits the time period anyway, since he's been gone. So before left the CSI's employment in this case.
Yes.
Sorry. So the concept of the phase 2 analysis that we talked about, the 2 phases, one being the determination of the boundaries of the basin that were set forth in the 1303 order. Now understanding the conflict phase as you defined it. Do you understand that second phase is in part designed to do that very thing that you hired a consultant to do, to look at forfeitures and restrictions and those that are using the water that they have been permitted?
Objection, the question contains portions that misstate the witness's prior testimony.
If I ever mistake your testimony, tell me. I didn't say that.
Your Honor, I'm gonna just object that counsel places a burden on the witness to do anything other than answer questions. She ends up keeping her head enough things, let alone what she's supposed to consult counsel about.
Here, the plaintiff is sued for a taking, alleging that in part 1309 and 1303 constitute a taking. I'm trying to derive information from her, considering the totality of circumstances, as whether she knows or doesn't know that phase 2 is designed in part to do those things she's just identified. It's also part of the rightness issue that we have presented to this court on a number of different occasions.
You know, my objection wasn't relevancy. My objection was that the counsel's question contained a summary, as he often does, of the witness's testimony that was inaccurate or misstated the testimony previously. Counsel can explore whatever subject he wants to explore. My objection is specifically when counsel prefaces his questions and by doing so mischaracterizes a witness's prior testimony, sometimes days of prior testimony. That's the subject of my objection. Your Honor, continues.
Today's counsel.
Yeah, I will do it again. 1303, you and I talked about what the scope of that was, and you said it was confined to the terms that are set forth in 1303, specifically to determine those items delineated A through F with respect to what's going to happen at the administrative adversary proceeding. Do you recall that testimony generally? That was the purpose of 1303?
I recall this morning, we looked at Ms. Fairbanks' procedure of history and that's, I know we looked at that this morning and that contained what 1303 was going to do.
And it contained essentially the contours of what 1303 set forth, which was to be determined following the adversary proceeding. Do you understand that generally?
I don't want to talk about what that was without going through it because we didn't go through all of those parameters that 1303 was intending to cover this morning. And I don't remember every single parameter that it was set to cover.
Okay, let's do it.
Let's do our morning recess.
Thank you, Your Honor.
Okay, reconvene as 11:15.
Thank you.
All right, we'll be reconvening 11:15, morning recess. Time to put those notes out. It's been been a little bit of a wild morning, and there's a lot going on in this state with water. We've got water in Elko City Council that'll be voted on, effluent water at 4 p.m. today, Elko City Council. We've got a water issue over in Lyon County with a conservancy group, Ritter, and then something new LLC called JD Wright Ranch. We've got quite a few things going on. I am in the middle and in between and doing quite a bit. So what I'll do is I'll put it on a Be Right Back. We'll throw some music up, and I will see each and every one of you comment there. If you want to reach out, text. The phone line is not open, even though it's on display there. I don't know why. It's because that's the way that I built the thing. What we're going to do is we'll be right back, and we'll give you more coverage on that. That's what we'll do. Let me get these notes out from the morning, though. Thank you so much for tuning in. It's W4Nevada Live. My name's Matthew Winterhawk. And we're Nevada. Just saying. We'll be right back.
Vegas shine, that's the stage. But baby, we're more than the glow. From Carson City to the back roads, we got that old state soul. Churchill ride, clock keep moving, Douglas wind through the pines, Elko sky, Esmeralda dreaming, every mile got a line. Hear that name roll slow like a river through the sand. One state, one home in every county band. We're Nevada, baby, Nevada all the way. We're Nevada, baby, from the night to the day. Carson City, we're Nevada, baby, Nevada all the way. Eureka Gold and Humboldt rivers, land of hills in the sun, Lincoln dust, Lyon County calling, mineral, we sing along. Nye County moon, Persian heartland, story got that old school flame. Washoe shake, white pine rising, say it baby, same sweet name. Hear that name roll slow like a promise in the land. One state, one home in every county band. We're Nevada, baby, Nevada all the way. We're Nevada, baby, from the night to the day. Carmel, no, we're Nevada, baby, Nevada all the way. And when the horns start crying, we remember every road, not just the bright windows, but the ones Yeah, pull up on Nevada, feel it. Bet the ground shake when we move. Hot as it hit like sunlight. State flag wave when we cruise. Build it from the dust up. They doubt us, now they copy the groove. County by county, we solid. Same spine, different views. Made it out the hard way. Long roads, no silver spoon. Sign my name on real things. Step off planes to open skies and moons. Locked in, don't ask me about the clout talk. I might just stare at you. Locked in, don't ask me about the clout talk. I might embarrass you. Stand tall and warm boots on cold stone. Holding ground steady, make them fall slow. Sunset go match the snow tone. No front in this, stay home. Lay a lamp for sagebrush to railroads. They say they know us, but they don't though. Run laps around the talk shows. Hear our name echo in town halls. Yo, Nevada, where you been at? Everywhere still working hard. 2-lane nights, wide open days. Long miles in every yard. Quick to stand up for the land. Don't push us, don't get me started. Locked in with the neighbors and locals. We keep it guarded. Everything I wear got dust on it. That mean it's activated. I was quiet when they slept on us. Now they act like they made it. Independent, proud and grounded. That's the state reputation. On top of the map for a reason. They try to underestimate it. They know this place authentic. Yeah, we live the truth. Stop over talking, show up, see what presents do. Standing on business in plain boots. Before I let this place get reshaped, I'll defend rules. Stand tall and warm boots on cold stone. Holding ground steady, make them fall slow. Sunset go match snow tones. No front in this, stay home. Lay a lamp for sagebrush to railroads. They say they know us, but they don't though. Run laps around the talk shows. Hear our name echo in town halls. Nevada. Battle born. Nevada, can we talk for a minute? Not politics, not noise, just home. W4Nevada live, Nevadans talking to Nevadans. I heard a mother down in Clark say something ain't right at the school today. I heard a washer say the water's thin, and nobody tells us where the money went. Out and now they've been raising their hands, asking who keeps selling off the land. Stories watching all those power lines, wondering who pays when the bill comes due this time. We don't need a polished speech, we just need a place to speak. Bring your heart, bring your name, bring the paper with the date. Can we talk Nevada? Can we tell the truth tonight? From the valleys to the mountains, bring what's hidden to the light. Call it in, text it in, let your county say its name. 17 voices singing, but the heartbeat is the same. Can we talk Nevada? This is home, this is us. Real voices, real receipts, real follow through, real trust. Carson City, I can hear you too. Churchill's got a story coming through. Douglas knows what pressure feels like. Elko's still working under big sky nights. Esmeralda, don't you disappear. Eureka, your voice belongs right here. Humboldt, Lincoln Line, every small town still gotta shine. Lion, Mineral, Persian too. White Pine, we ain't forgetting you. 17 counties, one lone one. Everybody carrying a different load. If it's water, let's talk about it. If it's school, let's talk about it. If it's budgets, let's talk about it. If it's buried, bring it out. If it's power, let's talk about it. If it's land, let's talk about it. If it's public, don't hide it. Nevada, we're done being quiet. Can we talk Nevada? tell the truth tonight. From the valleys to the mountains, bring what's hidden to the light.
It's a great song, but we gotta get back to this court case. Hope you guys are doing well.
I like this.
You know, half the time you go back, it's like, it's like it was already covered or it's already verified or. Exactly.
Please be seated, back on the record. Witnesses be taking the stand, and you may resume.
Okay, Ms. Carly, you had asked to see the scope of the 1303 hearings, and Brendan, if you would go back to states admitted exhibit 3719. And this is the notice that we looked at earlier, and then last week that sets forth those matters that the state engineer wanted comments or reports regarding. And feel free to walk through that if you like, see if it refreshes your recollection.
Well, that's weird. The internet just went down. So give me a second. Or at least the coverage of that did. Can see it too. Just a moment. We'll get back to the coverage. Wow. Wow. Come on, internet. Here we go. Little bit of that. I don't know what this white screen is. This must be what it does when I have to run errands, because like I'll come back and there's just something weird going on. See, still live on Instagram. Still live on Rumble. It's just a connection issue with this. Which is ironic, I'd say. Back it up. There we go. Hit cancel. Join from browser. Yeah, it's being silly. Well, technical issues, folks. We'll be right back in that meeting. Or will we? It's a pretty intense connection issue there.
Of the first day
There
of the
we go.
second phase. Do you remember that date in your mind?
It's very low connection.
Yes, it was in February. I don't remember the specific date, but 2026.
Right.
You and I agree, February and 2026.
I think it was the 26th, but be that as may be, a lot of participants, one by the name of Sylvia Harrison stood up, you know who she is?
Ms. Harrison, yes.
And remember her talking about how she thought there was a need for a new water inventory?
Yes,
Do
I
you know
recall
what
that.
My apologies. Do you know what a water inventory means, at least as she suggested should occur?
What my understanding was, and I did not speak to Ms. Harrison one-on-one. I thought she meant that the state engineer should create a new, as what did you and I agree to call it, a water chart?
Okay.
The water chart, and to update that and show the pumping from that point forward, and who had been and who had not, and putting all of that data into one chart. That's what I thought Ms. Harrison was asking. I don't know specifically that's what, if she meant something else, it's unknown to me.
I'm just trying to orient you to the terminology. Did you understand her when she used the term water inventory to do just what you and I have been discussing, have the state engineer look at the duty that's been pumped against the permitted rights, whether those rights could be, other rights could be canceled or forfeited? Did you understand that to be, in your view only, the definition of a water inventory as it was used?
I understood it to be a little more simplistic than what you just described, but as I say, I didn't speak to Ms. Harrison about it. I thought that she was simply saying that prior water chart should be updated, showing all the pumping from 2017, show 2018, 2019, et cetera, bring us current and show us what everyone on that chart, everyone within the lower White River flow system had been pumping, had a duty and had been pumping, and all of those years in between. That's what I thought she was asking for, but if she was asking for something different, I don't know what it was.
Okay. Do you think, in your view, with respect to what the state engineer should be doing, is exactly what you and I talked about, at least as early as phase 2, perhaps even earlier, look at the cancellation, forfeiture, and duty pumped as part of determining whether there's water available? Just from your opinion only.
My opinion only, yes, that's a part of his duties and what he has to do when he issues a permit, when he administers rights in his office, and all of his duties.
Okay, 0060, Brendan, I'm sorry, 3740. Just very briefly, the top of the paragraph, it says evidence and testimony were presented to argue that no amount of groundwater can be pumped from the carbonate aquifer, excuse me, or from the lower LWRFS without conflicting with Muddy River Decree or causing harm to the Wampadays. And then down below, if you would just read in the first 2 sentences of the last full paragraph.
Is this someone's, can we just see the prior page? I'm just
Sure.
trying to orient myself. Is this the state engineer's opinion, or is this he summarizing someone else at this point?
So the heading of at 0057 is long-term annual quantity of water that can be pumped. And he's giving you the recitals with regard to positions that parties have taken.
Okay, but there's no headers in here for the
No,
various
It's
parties.
falls under
It's just the state engineer's thoughts.
falls under the same heading that we just looked at.
Okay, thank you.
And just want you to read the first two sentences into the record of the final full paragraph.
The state engineer disagrees with SNWA and MVIC that the above quoted statement in the decree means that any amount of groundwater pumped within the headwaters that would reduce flow in the muddy river conflicts with decreed rights. The state engineer finds that capture or potential capture of the waters of a decreed system does not constitute a conflict with decreed right holders if the flow of the source is sufficient to serve decreed rights.
Did you understand that to mean that from the state engineer's perspective, as of the date the order was issued, that there was water that may be captured without conflict to the decreed rights?
I'm not sure. We would have to read more to make see because I don't know. Because he doesn't say whether or not, he doesn't answer his own question in the second sentence. It's just a statement.
After the order was entered, CSI took a petition for judicial review or filed a petition for judicial review. Is that accurate?
After 1309?
Yes.
Yes.
Ready, can I have 3741, please? Proposed exhibit 3741. Can you recognize this document, Ms. Cargan?
I think so. I'd need to see the rest of the pages.
Yep.
Yes, this is the denial of the large lot map, the 8 large lot map.
Is that when you say the denial? The first, it's from Leanne Ramirez to Emilia Cargill, and she's with the Department of Conservation and Natural Resources, and she attaches to that, it appears, the June 17th, 2020 correspondence from the state engineer.
Correct.
Okay. Is this the map that was submitted in June of 2019, to your recollection?
This is the Mylar, and I still come back to, I think it was submitted before then, and it was simply resubmitted in June of 2019.
Okay.
But be that as it may, it's at least the map that was submitted in the June 2019 timeframe.
And the second page is a document that's signed by, I mean, it references it being signed by Mr. Shell.
I can't see it. There we go. Yes, this shows that Mr. Shell signed this letter.
Just go to the front page, please, at 0002. The reference is the 8 large parcels intended for further subdivision, an estimated 2,000 acre feet annually from Coyote Springs LLC permits. What is the source of the 2,000 acre feet that CSI is proposing to use? And when I say source, is this the water in the GID, or is it permitted water, or is it both?
I'm not sure why it refers to 2,000 acre feet, because a large lot map only gets assigned 2 acre feet per parcel, so it should only be 16 acre feet. And it would come from the GID or the or Coyote Springs. If the GID didn't have enough water, then Coyote Springs would have to dedicate more water.
Okay.
But I believe at this point in time, the GID has 2,000 acre-feet of water,
Okay, when you say at this time, you mean as of June 17th,
2020, yes,
2020? Yeah.
yes.
Okay, and is that all certificated or partial certificated and partial uncertificated?
1,500 acre-feet is certificated, and I cannot recall if all 1,500 is owned by the GID or some of that, if 1,250 of what the GID has is certificated. I can't recall right now without looking at my charts to know.
Okay.
I don't remember at the moment.
At 0003, it talks about the final subdivision map presented and reviewed on June 13th. I think that's the time you and I agreed that that map was submitted. Yes?
That's the letter we looked at, yes.
Okay. And then it's as described in the state engineer's letter of September 7th, tentative approval was granted. Did CSI submit a will serve letter in connection with this map that's described?
Objection, asked and answered.
I'll allow it.
We would have to go back and look at my June 13, 2019 letter to see if I don't believe I had one, but we would just have to go back. We submitted the Stetson report as the state engineer was requiring be submitted at the time.
Has, just to your knowledge, from let's say 2010 forward through today's date, has CSI ever received a will serve commitment from the GID for any purpose?
Will serve letter. So to the best of my understanding, a will serve has never been formulated because the GID multi-party agreement does not require one.
Okay. And then the last paragraph says the Division of Water Resource recommends disapproval concerning water quantity as required by the statute. A subdivision based on water service by Coyote Springs. Oh, I'm sorry, a subdivision based on water service by a Coyote Springs Water Resource General Improvement District. It's recommending a disapproval, correct?
It says it recommends disapproval, but 3 paragraphs up, it states affirmatively that CS Coyote Spring investment groundwater permits have priority dates which may exceed the threshold of allowable pumping.
And it says may. It doesn't say that it does. It says may. Do you make a distinction in your mind?
I would agree it says may.
Okay. Leaving the door open. Perhaps in the future that water might be available. Did you read it that way?
Objection, calls for speculation, foundation.
I asked if she read it that way.
Oh,
Mr. Sylvester, at this point, Coyote Springs saw this letter as you're just done. We're not going to approve anything.
No more. This is the nail in the coffin. Is that your testimony?
I don't know that I've ever said nail in the coffin. That's not a phraseology I would use. But between this letter and 1309, which had just been issued 2 days earlier, CSI was, they're never going to let us move forward.
So you immediately took a petition for judicial review of that final decision by the state engineer.
Any discussions that I would have had regarding what CSI did would have been with Mr. Robinson and would be
I
privileged.
didn't ask you about any discussions. I said, did CSI take a petition for judicial review of this document that you described as being essentially the end?
No,
You know, because you've taken several PJRs, that they had the right to do so. To seek a review of that decision.
yes, I know that.
Could have sought a review from the district court and suggested that the decision was arbitrary or capricious. You understood that was part of the rights that you had, CSI had?
I understand that's what the statute provides for.
And that if their decision wasn't supported by substantial evidence, then it could theoretically overturn what you have referred to as essentially the final decision that gave rise to my words, end of the master plan community.
Objection mischaracterizes the witness's prior testimony concerning the
So she
combination
can, so she
of what.
can, correct.
Thank you, Your Honor.
What was your question, Mr. Sylvester?
It says that you could take a petition for judicial review. And if the reviewing court determined that the decision was not supported by substantial evidence, that decision would have been reversed.
Objection foundation.
Sustained.
How many times have you put your name on a petition for judicial review that we've seen so far? I count 2 at least. Do you agree with that?
Objection mischaracterizes the witness's prior testimony about who put her name on that document.
Sustained.
How many petitions for judicial review in this case that you have seen so far bear your name as caption counsel?
Relevancy, Your Honor.
She's talking about her knowledge and understanding of the rights under the terms of a petition for judicial review. If she says, I don't know what that means, I don't know what the standard is, then she can.
Relevancy, Your Honor.
Mr. Sylvester, I've never put my name onto any pleading. Council has put my name on pleadings for reasons that to this day, I don't know. And-
The question is, I'm sorry, I interrupted you.
No, go on, please.
I'm just talking foundation. With your knowledge as the COO, general counsel of CSI, whose name appears rightfully or wrongfully, voluntarily or otherwise, on petitions for judicial review. Did you understand that if the reviewing court determined the decision was not supported by substantial evidence, it could be overturned?
The statute provides for a petition for judicial review, and there is a process in the statute, and I don't have the statute memorized. The statute is the statute for what it provides for.
I'm just asking your understanding. If you don't have one, I'll go to the next question. I'm just trying to understand if you knew at the time that there was that right, that if you were successful, that decision, however you characterized it, could be reversed. That's all I'm asking.
Objection repeatedly asked and answered.
It hasn't been answered, John. I've asked it 5 times and I had to leave 5 minutes of foundation to get the answer. She doesn't know. That's okay too. I'm just asking if she knows that would have been the result to the extent that CSI was successful in pursuing a petition for judicial review.
4th time it's been answered.
Last time.
It's the 4th time it's been asked, Your Honor.
It's been
Last
asked
time.
at least 4 times. It hasn't yet answered.
It's been answered 4 times, Your
Go
Honor.
ahead, please.
This is the last time.
If I get an answer, please, Your Honor. I mean, that's all I'm asking.
Your Honor, this question's been asked and answered. We're back to the same pattern as before. Doesn't like the answer, doesn't want his exact answer, then he just keeps peppering the witness to change her testimony. That's what's
last
unfair
time.
about it.
An answer. Do you understand? Did you understand at the time that a petition for judicial review was not filed? That if it had been filed and if CSI was successful, that decision could have been reversed?
Under the statutory process, yes.
Brendan, can I have 3742, please? And tell me, Ms. Cargill, this is a document that is filed on July 8th, 2020. The motion to dismiss, it's filed by Mr. Harema. Your name appears on it, so too does Mr. Robinson's. It's a motion to dismiss. You turn to the next page, it appears to be the dismissal of the then pending 1303 petition for judicial review. Just tell me if that refreshes your recollection.
I see that it's a motion to dismiss filed and signed by Mr. Robinson.
Essentially, it came out after, I mean, the 1309 came out in June as a result of 1309, which I think you and I can agree terminated 1303. You recall that generally?
Objection. Document speaks for itself. Foundation.
I'm just
Sustained.
Ms. Cargill, do you know what the effect of 1309 was on 1303?
Same objection. Foundation calls for the.
Just asked if she knows.
I cannot remember right now whether or not 1309 specifically said all of 1303 was overruled or not. Or if I'm conflating a different order, if that exact language was in 1309 or not.
Okay. I'd offer proposed exhibit 3742, please.
As long as it's just a plea, Your Honor, I don't have any objection to this being part of the corpus of the court's.
Right.
record.
Ernie, can I have 3744, please? Proposed exhibit 3744. And Ms. Cargill, this is an order entered on 9/2/2020. It appears to be granting the motion to dismiss filed by Mr. Robeson, yourself and Mr. Hermera. That's at 0002. You can see the order dismissing the petition for judicial review.
I see Mr. Robinson's signature on it, yes.
I offer proposed exhibit 3744.
Can I just see the extended, Jeff? No objection.
Admitted.
Now, after 1309 is issued, CSI takes a petition for judicial review. Brandon, may I have state's proposed exhibits 3743, please? And this is a document filed July 9th, 2020, petition for judicial review bearing, it looks like Mr. Hermera's, Kent Robinson's, Mr. Coulthard, and you. Are you familiar with that document?
I'm familiar with the document. It's Harima, Brad Harima.
Don't tell him I mispronounced his name. Harima.
Yes, I'm familiar with this document, assuming it's all there. Yes.
Fair to say as COO and General Counsel, you would have reviewed this petition and approved it before it was filed?
I would have reviewed it and I would have deferred to Mr. Harima and Mr. Robinson and Mr. Coulthard on the specific contents of it. I would have reviewed it.
Brandon, go to 0020, please. And this is at page, I'm sorry, paragraph 53, those outline the topics that you wanted to see earlier in connection with 1309, just to refresh your recollection as to what those were.
That looks familiar, yes.
Brandon, can I go to 0028, please? And if you would, Ms. Cargill, just read in paragraph 71 into the record.
71. Throughout Order 1309, the state engineer, quote, recognizes, end quote, that Order 1309 will serve as an initial step toward management of the newly defined LWRFS hydrographic basin, parenthetical emphasis added, end parenthetical. The word, quote, recognize, end quote, is neither a finding nor a ruling. It is simply the observation of something by the state engineer. The state engineer also identifies the need for, quote, an effective management scheme, end quote, to, quote, provide for the flexibility to adjust boundaries based on additional information, retain the ability to address unique management issues on a sub-basin scale, and maintain partnership with water users who may be affected by management actions through the LWRFS, end quote, footnote 27. However, the State Engineers Order 1309 provides for neither a management scheme nor a plan for the development of such a management scheme. Accordingly, the State Engineers Order 1309 is incomplete, and as a result, his issuance of Order 1309 is both arbitrary and capricious.
I'd offer proposed exhibit 3743.
Same thing, kind of just take a look.
Yeah. It's got the attached 16 page.
No objection.
Admitted.
Can I have proposed exhibit 3782, please? Now, there were a number of stakeholders that filed petitions for judicial review of Order 1309. Do you recall that?
Yes, 13, 14, 15, something like that, I think altogether.
We see that on the front page. Carries on to the next page as well. And ultimately, if you recall, and only if you recall, Judge Yeager in 2022 held that the state engineer did not have the authority to combine the basins, and therefore he essentially held that the 1309 was not enforceable. Again, just if you understand that.
Yes.
Okay. If I haven't already, offer proposed exhibit 3782.
I think it's in, but no objection on.
Admitted.
Thank you. Now, after that order is entered, which essentially strikes 1309, would you agree with that terminology?
Yes.
If we can turn to proposed exhibit 3785, please. And that order, just to orient you in time again, is entered July 9th, 2020. And then on 3785, tell me if you can identify that exchange of emails.
This is a series of emails between Kyla Casella from VTN Nevada and Ms. Christy Cooper and some other staff members in the state engineer's office, Anna Jet Medina and Jennifer Davis, regarding requests for an appointment for a map.
Appointment for what map? Do you have in mind what map you're referring to?
Without going deeper into the emails, I feel that this was the same large lot Mylar, because as you and I've discussed before, you have to have the large lot map done before you can proceed with the Mylar for the 575 unit subdivision. So this should be the large lot map for 8 large lots, 16 acre feet of water.
Was it the same large map lot that we saw that was denied by Mr. Shell? We went through that denial. Is that the same map? To your recollection?
To my recollection, yes, it's the same map. There wouldn't have been any changes to it.
We said it's the same map, but essentially because it was stricken 1309, you're now going to present it again, right?
Yes.
Okay. And ultimately, you didn't get an appointment, or VTN or whoever was going to present the map didn't get an appointment with the state engineer. Is that accurate?
Yes, I believe Ms. Cooper at one point said you can drop it off, but we can't do anything with it.
Okay. I would offer state's proposed exhibit 3785.
No objection.
Ms. Cargill, on the top, that's the email from Christy Cooper on May 9th, 2022.
Yes.
It says, "Hi Kayla, sorry for the confusion, but this map signature request has to be approved by Carson City first before scheduling. I'll get back to you as soon as possible." Did you ever form some understanding as to why Ms. Cooper indicated to Ms. Casella why it had to be approved or sent to Carson City?
I don't think I ever did. I believe there was an earlier email in the chain, unless there was a different chain, where Ms. Cooper told Kyla Casella something a little bit different than that, but it was more along the lines of you can drop it off, but it's just gonna sit here.
After the findings of fact by Judge Yeager were entered, you recall that one or more stakeholders filed an appeal with the Nevada Supreme Court.
Yes, I recall. I don't remember who filed and who were petitioners or respondents, and there were a lot of people who ended up filing various documents in that.
We'll look through just a few of them. Brandon, can I have proposed exhibit 3788? And this is a document styled amended notice of appeal dated May 19th, 2022. And it appears on the caption counsel is the Attorney General, Mr. Shaborsky, Mr. Balatin et al. And this is a amended notice of appeal of the findings of fact made by Judge Yeager. Do you recognize that generally?
I see that it's an amended notice of appeal filed by the state engineer,
Okay, but-
the Attorney General's office.
Sure. Go to 002, Brendan, just so we can orient the witness. It is an appeal of the court's findings of fact and conclusions of law filed April 19th, 2022.
Yes, I see that that's what it says.
That offer proposed exhibit 3788.
As part of the corpus of the court's record, no objection to that purpose.
Admitted.
And to your point, if we can, Brendan, turn to 3790. This is appears to be also a notice of appeal. I'm sorry, this is an emergency motion to stay. Brendan, if you go to 005 of that document. You recall one or more parties after an appeal had been lodged filing a motion for an emergency stay to the Supreme Court to stay the effectiveness of Judge Yeager's ruling.
I recall that one or more parties filed a motion to stay, yes.
And this was actually filed, if we look at 005, it appears to have been filed on behalf of the Center for Biological Diversity.
I see it says that, yes.
Offer state's proposed exhibit 3790.
As part of the court's records for that purpose, no objection.
Submitted.
Proposed exhibit 3789, please, Brendan. This is an emergency motion to stay. And this time it's filed by SNWA. You see it on the front page?
Yes, I see Southern Nevada Water Authority as appellant.
And at 002, Brendan, under paragraph 1, if Ms. Cargill read into the record, the sentence that begins immediate action.
Immediate action is required because developers have already submitted new subdivision maps for approval by the state engineer and plan to pump an additional 536 acre feet annum AFA of groundwater while this appeal is pending.
Did you form the understanding that SNW was concerned that if homes were built, ultimately there may not be water to service those homes?
Objection foundation. Call for participation.
Did you form an understanding, you personally, having reviewed the document, that SNWA had a concern that if homes were built but without a stay, that homeowners may go without water?
I don't recall if SNWA's appeal or the request for stay included that as grounds or not, Mr. Sylvester. We would just have to, you could read in more of the document to the record.
Thanks. I appreciate your answer. Offer proposed exhibit 3789, please.
As part of the court's records for that purpose, no objection.
Admitted.
May I have 379, proposed exhibit 3792, please? This is a joinder, you can see the second page, by the state engineer to the emergency motion to stay filed by SNWA. Recognize that to at least be the document.
Yes, I mean, it says it's the state engineer's partial joinder to not only Southern Nevada water authorities, but I think it also says it's a joinder to, they're joining with Center for Biological Diversity also.
Agreed. I offer proposed exhibit 3792.
As part of the corpus of the court's record, no objection, Your Honor.
Admitted.
May I have 3946, please?
What's the number again?
3946. And Ms. Cargill, this is a order granting stay by the Nevada Supreme Court, and you can see that at 003, Brendan. I'd offer proposed exhibit 3946.
As part of the court's record, for that purpose, no objection.
Admitted.
So that's issued, that stay is issued on October 3rd, 2022. That's the front page of the document. I think, let me just double check that for you. Yes. You recognize that to be the date?
Yes, I see the date there.
And that stay remained in effect until the Supreme Court rendered the decision in the Sullivan case. Do you recall that?
I don't doubt it. I don't recall if this had a limitation on it or if the stay actually said. We just have to read how long the stay was for.
Okay. But the Supreme Court issued this decision in the Sullivan versus Lincoln County Water District on January 25th, 2024. I'm happy to show you the document, but I think we can agree that's the date. Assuming that the stay remained in place, that stay was in place for approximately almost 2 years.
Approximately, yes.
Okay. State engineer is been told by Judge Yeager he doesn't have the authority to combine these basins, and therefore, unless and until that order is reversed, he can't combine the basins. Do you understand that at least from a 30,000 foot level?
Objection foundation.
Sustained.
Do you understand what the effect of the stay was on Judge Yeager's order? As the effectiveness of her order?
From a very non-litigation perspective, I understood it to be that Judge Yeager's order couldn't be enforced, meaning the state engineer did not lose his authority.
Okay. Now, although the state engineer had denied the 2020 map and the order had been entered striking 1303, CSI went forward and submitted a map to Clark County. Is that accurate?
On a real simple level, yes.
Okay. You want to expand on the answer?
Yes.
Oh, go ahead.
Under NRS 278, your maps expire after a certain period of time, and there's nothing, I mean, they're beyond extension. You only can extend a certain 2 times, I think, and then you must file a whole new application, no matter what. No, there's no exceptions to that. And so Coyote Springs submitted the map to preserve the map, because that's how it's been explained to me by Clark County staff, that to preserve the map, you actually have to file a new application, and it then operates as an extension of sorts, but an extension won't cut it, if my answer makes
I
sense.
think it does.
And so Coyote Springs submitted what it submitted in order, in essence, to get an extension of the map that was resubmitted.
Okay. Brenda, can I have proposed exhibit 3783?
That's my memory anyway. You may show me a document and I may be completely out of line.
Then again, I may not. She can identify that document.
This is a tentative map application for Village A 575 unit subdivision map. And the parcel numbers should be attached. It's submitted by, this particular application is submitted by Coyote Springs, Nevada LLC. And there may be a corresponding application submitted by Coyote Spring Investments also. Yeah, because I believe some of the parcels overlapped, and the application number is TM 22-500152. And then you can see the notes in the right-hand corner that are written by hand that it used to be TM 18-500105.
And is this one of the maps you're talking about that had to be renewed?
That's my, Mr. Sylvester, that's my recollection right now.
This comes after, obviously, temporally, the opinion letter and the rescission of the opinion letter, correct?
Objection ambiguous.
Sustained.
Hey, do you know what I mean when I say opinion letter, Ms. Cargill?
I don't remember what you mean by that.
The May 16th, 2018 letter that we've been referring to as the opinion letter?
I forgot that's what you'd been referring to it as. Yes, this was, it says it was filed on July 19th, 2022.
And this is after 1303, right? But it was January 2019, you and I can agree,
Yes, this is after that.
after the entry of 1309 in June of 2020, correct?
Correct.
And at this point, when it's submitted, is CSI still hopeful that it'll get water to service its master plan community?
Objection. Question's been asked and answered.
Overruled.
I don't think that, I don't think that Coyote Springs was doing anything other than preserving rights by filing this.
That's my question. My question was, at the time this was filed, was CSI hopeful that it would in the future get water to service the master plan community?
Objection. Question was just asked and answered.
Overruled.
Perhaps, Mr. Sylvester, but I come back to, had we known any of the other emails, Mr. King saying we're going to deny the maps, or the order being described as a curtailment of Coyote Springs on what we looked at on the privilege log, or any of those other emails and descriptions, or Mr. Shell saying the maps just sat in his office. This was purely, I would almost call it rote, simply to do in order to make sure that rights were not terminated, because that's just, it was by rote.
But it is, after setting aside the opinion letter and the information you received during discovery, what you did say is that 2020 denial was the end, as you defined it. Once they got the 2020 denial, you formed the impression that that was the end of the master plan community. This comes after that date, correct?
Objection argumentative.
Overruled.
Yes, that's why I say it was by rote, simply to make sure that it's hard to let go sometimes.
I understand. But you did testify in direct examination about the extensions of time that were applied for and granted after 2020, and I think the most recent one was extending that time period through 2027, right? You saw that application, we talked about that on cross-examination.
Only because I was just thinking about maps and extensions. Are you talking about this sort of extension, or are you talking about the extensions of time on beneficial use?
Yes. Beneficial use extension.
Okay. Yes, Coyote Springs filed extensions of time. Had we not, and had the state engineer taken our water rights, I'm not the litigator in the room, but it may have vitiated our case. Yes, we continue to file extensions of time.
They have vitiated your case?
Vitiated our case.
Takings case?
Yes.
Oh. All right, but fair to say, at least after the denial of the map in 2020, CSI is still going forward, hopefully, to pursue the development of the master plan community. Is that accurate?
Objection asked and answered.
Overruled.
In what year did you just say?
After 2020, when you got that map, you said that you said that was the end. Is it true to say that Coyote Springs continued after that point in time to pursue development of the master plan community?
I don't believe we pursued anything. We finished our contracts as you and I talked about, and we filed extensions of time. And as I've described, this is really, this map application that we just looked at in 3783 is really along the lines of an extension of time to keep,
Sorry,
just to keep something so it doesn't go away.
but for what purpose? You've already formed the impression that the state engineer has killed the project, right? You're never going to get water. Is that true?
Yes.
So what are you preserving? The project is dead.
Objection. Questions asked and answered.
Sustained.
You indicate you're trying to preserve the maps and you're trying to preserve the water rights. For what purpose? After you determined that project was dead in 2020.
And Your Honor, the question, I'm just going to caution the witness not to disclose communications you may have with your counsel. If that would be part of your answer, don't disclose that.
Sustained.
I don't want to know about any conversations you have with lawyers or whether you had to continue that in support of this case. I just want to know from you as a COO and general counsel, why are you continuing to pursue the preservation of the maps and the water rights if you understood and believe that the project was dead?
I probably wasn't clear in my earlier answer when I said what I said about the litigation. It was with, trying to think, Mr. Coulthard was counsel at the time, and Mr. Robinson was as well. It would have been through communications and discussions amongst attorneys
Okay.
and myself.
So just to clarify the record, outside of communication council, you don't have an independent understanding as to why CSI was pursuing, though a few moments ago you said sometimes it's hard to say no or hard to let it go.
Correct.
And you participated, at least initially, in the phase 2 proceeding? You were there, Miss Winston was there, correct?
Yes, Ms. Winston and I were both present in February 2026.
All right, going back to 171, I think we talked about the map, and go to now I'm sorry, that was 170. Go to 171. I'm proposing exhibit 3795, Brendan, please. Do you want that one? Yeah. And tell me if you can identify this document.
These appear to be two different letters from the Las Vegas Valley Water District. Each letter is addressed to Ms. Tina Garrison at Clark County Public Works Survey Department Mapping Team. One is dated August 22nd, 2022, and the other is dated August 15th, 2022. And they're in regards to two different maps.
Okay, are they responding to one or more of the tentative maps that you submitted that we looked at as 3783? Your recollection?
I'm not sure. I just don't remember.
Would it help if I showed you 3783 again?
No, I'm just trying to read the two letters.
I see. But is it fair to say that Las Vegas Valley Water District as a GID wouldn't recommend approval of those maps?
I believe that they're saying because of State Engineer Order 1309 in each of them. I was just trying to read them so I could be familiar. The letter dated August 22nd says that because of State Engineer Order 1309, and the August 15th letter says it also looks to and describes because of 1309.
Okay, let's just put the second bullet point under that. And if you would just read it into the record.
This is from the August 15th letter. State Engineer Order 1309, which addresses the Lower White River Flow System, parenthetical LWRFS and parenthetical, has been appealed to the Nevada Supreme Court. Among other issues, Order 1309 addressed the amount of groundwater that may be sustainably pumped in the LWRFS, which includes Coyote Spring Valley. Order 1309 recognized that the permitted groundwater rights in the region exceed the groundwater that can be sustainably pumped. Until such issues have been resolved, the district cannot confirm whether additional groundwater development in the LWRFS will be allowed or what conditions might be placed on such uses.
Okay, and then the next bullet point indicates that the concern of the district is that pumping additional water in Coyote Springs Valley is likely to cause conflicts with existing senior rights and jeopardize the Moabit days, a fish endemic to the LWRFS and designated as endangered. I would offer state proposed exhibits 3795.
No objection, Your Honor.
Admitted.
Brent, may I have proposed exhibit 3799? Tell me, Ms. Cargill, if you can identify that document.
Yes, this is a appeal filed by the Las Vegas Valley Water District after a planning commission meeting that took place on September 6, 2022. And the Las Vegas Valley Water District filed an appeal saying source and availability of water not demonstrated. And it was dated September 7th, 2022, and it says it was filed by Tabitha Simmons.
Offer proposed exhibit 3799.
Just take a look at this one, maybe it is, Jeff. No objection, Your Honor.
Admitted.
This was after, as I recall the timeline, planning had approved the map. Is that accurate?
Correct. The planning commission meeting this stated it was September 6, 2022. And the Las Vegas Valley Water District was appealing planning commission's decision.
Okay. May I have 3798, proposed exhibit 3798. This is an email from you to Ken Nicholson of VTN and Greg Borgal. It's dated September 7th, 2022. And tell me if you identify what the document is.
Yes, this is an email, as you said, from me to Greg Borgal. And I'm saying that I'm going to be outlining all the materials for the October 4th, 2022 hearing, and that I will send an outline past Council Coulthard and Council Robison, and that I was going to be working on it right away because I'm dating this September 7th, the day that we heard of the appeal, and the hearing is October 4th, so we don't have a lot of time.
Okay. But you knew that LBVWD would appeal, correct? That's what you say.
My recollection is they were at the hearing at the planning commission meeting and they objected. So that, and it is very possible that they even told me at the hearing that they were going to appeal. I don't remember why I said that right now, but I just don't remember why I said that. That's my guess right now.
Offer proposed exhibit 3798.
Jeff, I'm just taking a look. No objection, Your Honor.
Admitted.
Brent, may I propose exhibit 3801? And Ms. Cargill, this is a document dated September 28th, 2022. It's on the Las Vegas Valley Water District letterhead. And it is directed to the Board of Clark County Commissioners appealing tentative map 22-5001. Coyote Springs Village, a parcel A-D approval. You recognize this document?
Yes, I recognize it. It's been a while since I've looked at it, but yes, I recognize it.
And this is the appeal, if you will, from the decision granting the tentative map. Is that accurate, at least from your understanding?
Yes.
I offer proposed exhibit 3801. Yeah, sure. Nothing.
Yeah, no objection.
Have you read this recently?
Sometime probably within the past year, I reread it. Maybe even during my deposition. I don't remember, Mr. Sylvester. Not recently, let's put it that way.
Did you understand this to be on behalf of Las Vegas Valley Water District as the general manager of the GID?
Yes, it says so in the second paragraph.
Okay. The first full paragraph, it says the district is appealing. Do you see that language?
Yes,
And if you can read that into the record to the end of the paragraph, please.
the Las Vegas Valley Water District, parenthetical district, is appealing the Planning Commission's September 6, 2022 approval of TM 22 500152, parenthetical, the map, and parenthetical footnote 1. Coyote Springs Investment LLC, parenthetical developers, unparenthetical, submitted the map to facilitate construction of nearly 600 homes in Coyote Spring Valley. The district is appealing because the Planning Commission failed to consider the adequacy of the water supply as required by Clark County Code Section 30.04.040 sub 2 sub B and NRS 278.349 sub 3. The water rights intended to support development at Coyote Springs are insufficient because they cannot be used without 1, conflicting with senior decreed rights to the Muddy River, or 2, impacting the endangered Moapa dace. These important issues are pending before the Nevada Supreme Court. The Zoning Commission should therefore reverse the Planning Commission's decision and deny the map without prejudice.
Thank you. If you go to 0002, and Brendan, highlight the third paragraph, and if you'd read that paragraph into the record, please.
Order 1309 is the culmination of decades of testing, monitoring, and sifting through data and testimony prior to the 2-week hearing related to Order 1309 held in September and October of 2019. The state engineer solicited expert and rebuttal reports from all interested parties, footnote 13. The district submitted expert reports on hydrology and the Moapa dace, footnote 14. Several months after the hearing, the state engineer issued Order 1309, which is largely consistent with the district's positions presented at the hearing. Notably, Order 1309 concluded that the quote subbasins end quote of the LWRFS did in fact act as a single hydrographic basin, and that paper water rights vastly exceeded the actual volume of water that could be pumped without conflicting with existing senior rights or harming the Moapa dace, footnote 15.
Brendan, can I go to 0004? And read into the record the first full paragraph under the heading, developers knew of the water supply concerns and assumed the risk.
Developers knew of the water supply concerns and assumed the risks. As evident from the discussions above, concerns over groundwater supply in the LWRFS are not new and date back as far as 1984, footnote 26. Without question, developers knew that relying on their groundwater rights to develop in Coyote Spring Valley would be risky and potentially disastrous if done without a better understanding of the hydrology. Indeed, The state engineer explicitly warned them of the quote, risk, end quote, and possible quote, disastrous, end quote, consequences in 2002 when he served Order 1169 on them and ordered developers and others to undertake the pump test, footnote 27.
And if you would, the next paragraph, and that might take us to the break.
It may get rid of my voice too, Mr. Sylvester. Notably, the developers received the state engine. Sorry, my screen keeps moving. Okay. Notably, the developers received the state engineer's warning for nearly 4 years before the county commissioners created the GID, footnote 28. At the requisite public hearing where the developers promoted the GID's creation, the district staff explained, quote, "This is different from other developments. It must acquire and secure its own water resources. They must proceed at their own risk. This GID is not subsidized by quote, parenthetical local governments, end quote, close parenthetical, and developers, quote, must proceed at their own risk, footnote 29. The developers immediately confirmed staff's characterization, quote, staff pointed out it's the developers who are assuming all the risk under this GID and under this agreement. Whether it's for acquisition of water, subsidy of the operating costs, that is really borne by ourselves and us developers, end quote, footnote 30. The developers continued, quote, I also feel like it's important to point out that the water sources is one that is outside of existing allocations within Clark County. We are living on our own water resources that don't have to take away from any of the water rights that would otherwise be used for the rest of Clark County residents, end quote, footnote 31.
And as a result of that appeal, is it accurate to say that the Clark County Commission reversed the planning's approval of that subdivision map?
Yes, based on Order 1309.
Brenda, can I have state's proposed exhibit 3804? And do you recognize this document, Mr. Cargill? Styled notice of final action.
Of the Clark County Zoning Commission from October 4, 2022.
If we turn to 0014 of that document. Item 42, is this the denial or the granting without prejudice of the appeal to your recollection?
Yes, that's what it says.
Offer state proposed exhibit 3804.
No objection.
Admitted.
And then at Brendan, if we go to state's proposed exhibit 3805. And this is a petition for judicial review of the Board of County Commissioners Notice of Final Action filed November 7th, 2022. As Kent Robison and others, along with Ms. Cargill as caption counsel. Do you recognize the document?
I recognize the document.
I'd offer state's proposed exhibit 3805. I think.
Judge, no objection as part of the court's record.
Admitted.
Might be a good breaking point, Your Honor.
All right, let's break now for lunch, reconvene at 1:15.
Thank you, Your Honor. All right.
Well, you heard that. We're going to lunch right now. We'll be reconvening at 1:15 p.m. I'm going to get that lunch update out. Currently in the background, I'm tracking a ton of water rights through Walker Basin Conservancy. What I do think I'll do is we'll go to break and then we'll get back. You'll see those updates out there. You can share it out, share this video out, let everybody know We'll be back around 1 o'clock, 1 p.m. this afternoon. I'll start the stream and get it up and going. I look forward to continuing this. This is day 8 trial Coyote Springs versus Nevada. Once again, you're watching W4Nevada Live. My name is Matthew Winterhawk, and thank you so much for tuning in today. And we will see you at 1 o'clock. Have a great day.